Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Edward Elgar Publishing Limited, an independent publishers based in Cheltenham and elsewhere. They produce really first-class books. This particular book excuse me, is on the art of mooting. I think it's a very important area for any practicing barrister and certainly for solicitors and anybody who's involved in public speaking. I think this is an important area. The subtitle for the book is Theories, Principles and Practice, and it's been written by Thomas and Lucy Cradduck. This is an important book, and one that I'm pretty certain is something which many people would need a little bit of assistance with if they've never done much in the way of debating at school or anything else, and need some sort of honing of skills when it comes to looking at how in fact one approaches a particular subject. The title that Elizabeth and I have given the review is Looking to Perfect Your Performance in Court. Check out this new title on the art of mooting. Well, that's probably a very sensible thing to do, because the point about this particular book is that it's to give you some sort of guidance as to what you might need to do. Because when I was called to the bar, I'd already done a great deal of public speaking, and I'd been involved in having been elected to a local authority, been involved in a lot of substantial disagreements with my opponents over the way we would do things. So therefore I came into the profession in a different way from younger people who won't have had the privilege that I had of being elected to, in fact I've served on 2 local authorities, where I've actually been able to see what happens, apart from of course all the work that I do as a barrister. Let's look at the book. Here it is. It's a hardback. There we go. It's a small book, spine, and then on the back some blurb. It runs to something approaching to just over 200 pages. The index is by page numbering. It's not a big index at all. It's not a big book. I mean, there's a nice bibliography at the back, and if you go to the front of the book, there's a little dedication. We only review books that we like. I do not review a book which I don't think much of. There's no point. I don't want to insult the author, the authors. This book is a good book, and that's why I'm reviewing it. Those are the people involved in it. Then there's the blurb about Elgar. It's available as an ebook as well, which you can get hold of. There's the contents section. Contents, part 1 theories, part 2 principles, part 3 practice. There are 10 chapters in total, and a couple of appendices, and then the bibliography in the index. There are some figures, and there's some tables as well. Quite interesting. I did think it was going a little bit technical for me, I have to say, but there we go. There's a very interesting comment from Catherine Holmes, who's Chief Justice, Supreme Court of Queensland, Brisbane, Australia, dated April 2019. She says, "A life at the bar can be a very rewarding one. For the advocate, though, a significant challenge of appearing in court may lie not in any lack of ability to understand the law," that's true, "or to identify the submissions that need to be made, but in the need to develop an effective delivery and a capacity to respond readily and appropriately to the bench's questions." Exactly so. I don't need to say any more. That little paragraph sums up exactly why this book is for you. Now, there are some acknowledgements as well from various people. Then there's a very small number of abbreviations. Always helpful to have them. You just suddenly get you freeze on something and think, "Oh, I can't remember what that is," and then you suddenly do. There's the structure, starting with an introduction, overview. There's footnoting galore all the way through. You can see, and then it runs all the way. What is a mooting competition? Preparing for a competition. Developing mooting cognitive skills, and so forth, running all the way through. Pronunciation. They've got to be very careful. It can very upset people if you make a remark that they don't pronounce things properly. As some people have found out, it is not H, it is H, and so forth. And you don't say ain't, you say isn't. there are all sorts of things, and it's not snobbery. It's got nothing to do with snobbery. It's just the way it should be done, and I'm afraid that's a problem. But don't worry about it, because that does happen, and we get there in the end. So what do we say about the book? Mooting may be an art, as the title of this new publication from Edward Elgar suggests, but judging from the rigorous analysis which authors Thomas and Lucy Cradduck apply to the subject, you could be forgiven for referring to mooting as a science. Quote, considering the skills required as detailed in this book, mooting can get technical. But there you might say it's a moot point. The point being that don't overdo it. Because actually, whenever I think of any speech, I do actually structure it. And I have to say, some of the really expert advocates I've come across with very strong, sharp views about a point of law still don't have the basic structure. And they're all over the place when they're making a submission in court, which is of no help if I'm judging it, or it's of no help if I'm the other side trying to respond and fathom out what he's just been saying, or she's just been saying, because I haven't quite followed, because it's flitted from one point to another. So structure is always important. Essentially then, thinking about this, a moot is a debate engaged in competitive... I'll start again. A moot is a debate engaged in competitively on a formal basis, mainly in law schools, in common law jurisdictions, and it's viewed generally as a reliable means of assessing students' advocacy skills. Such skills therefore become the focus of this book, and for aspiring advocates especially, the book emerges as an absorbing read. Now I'm going to say something before I go any further with this, and that is you don't write out a speech when you're an advocate. It's not done like that. What you do is you obviously deliver it naturally, but you do have points. So you can have points, bullet points and so forth, but it's always important to remember that point. Some people will write out speeches in complete speeches, but that isn't actually the best way of doing it. It doesn't really work quite the way you want. Let me move on anyway to the book itself, because as a moot is a competition, its presentation, say the authors, involves all the domains of human mental activity: cognitive, psychomotive and affective. And so this tripartite view of human mental activity informs most of the theorising in this text, and very interesting it is indeed, because as Stuart Barron of 3 New Square has observed, good advocacy synthesises thoughtfulness and experience. So does this book. And I think he's absolutely right, because you've got to think about what you're doing. You've also got to bear in mind what your audience is like. Know your judge, know what you're doing, so that you're not wasting a lot of time. The authors of this work are both senior lecturers at the Faculty of Law, Queensland University of Technology, Brisbane, Australia. Not too surprising then that they occasionally draw comparisons or contrasts when appropriate between approaches to mooting and engineering education. They offer, for example, a noteworthy quote from the Journal of Engineering Education, which compares the mooting approach with the focus of engineering education on foundational knowledge, computational skills and their application. They nevertheless place considerable emphasis on cognitive domain development, implying that attitudinal and behavioural dimensions must inevitably be brought into play in a successful moot. Now that is taking a quite scientific approach to it, but you can see where they're coming from, and I think every person is going to do it their own way in any event, but it is worth thinking about the structure. And judging from the book's extensive bibliography, the authors have amassed a formidable amount of research which has obviously informed their analysis, and throughout the book, however, it's shown that the theoretical does influence and inform the practical. And I think this is one area where that is important, and I'm sure those about to embark on practice as a barrister for instance, would find this book very helpful. Now, Catherine Holmes, who I mentioned, Chief Justice, Supreme Court of Queensland, writes the foreword and remarks that for the advocate a single challenge of appearing in court may lie not in any lack of ability to understand the law or to identify the submissions, but the need to develop an effective delivery and a capacity to respond readily and appropriately to the bench. As I said, that's right at the beginning of her forward. I think it's worth repeating that point, because you've got one of the points about successful advocacy, and mooting to a certain extent comes into this, is when I'm in court, for instance, I may be making a submission and then the judge will interrupt me and ask, well, no, that's not right, Mr. Taylor, no, could you explain that further? In other words, they're probing further with curiosity, so you can understand why they wish to do it. Let me conclude by saying this: whether art or science is a bit of both. Mooting demands a multifaceted skill set on which the authors themselves, being experienced moot coaches, are well qualified to elucidate. From students to experienced barristers, then, who are interested in developing an effective delivery in court. And that's what this is about, an effective delivery in court. This book demands a serious read. And you need it, basically, if you're going to be... If you have a worry, I mean, I obviously the self-confidence comes into this and everything else, but if you have a worry about this sort of thing, this book will help you. And I'm sure you know that at the end of it all, you will get there. But we all, every single one of us, and I can think of famous people I've stood on a platform with, and they've shaken a bit. Just a bit of shaking. Because you never quite know. Then you get into the stride and you're there. So just take it from someone who's done a little bit of it, that you get there in the end. And this book will help you, okay? So the publication date of the hardback from Elgar is the 31st of October 2019. I like the book, and it's well worth getting. Let's just have a look. It talks about coaching there for us. I'll just open this in the middle. Then team dynamics. Because, of course, I'm talking generally because I'm the only barrister representing. But I've got a couple of cases where I will be one of a team of people. So team dynamics come into it. That's quite useful as well. You've also got things, written submissions. Very important today. And again, written submissions. I know we're talking about mooting, but it's incredibly important to think about legal analytical processes, research, natural law and positivism. Oh dear, and Dworkin. We're getting into very heavy stuff here. Then out of that we come back to the practical stuff, because right at the end you get measuring the total development of mooting skills. Conclusion. The point is that with a book like this, it will give you, I hope, a little bit of confidence, but it will also give something else. It will give you an idea of the structure. And just remember, we've all been there before, so it's not as difficult as it might appear. Thank you anyway to Mark and Lucy and to Elgar for producing this work. I found it fascinating. I'm delighted to have been able to review it. Thank you. Bye-bye.